County Court Law number 2 is now in session. The court is in session and calls number M333474. Case is style of State of Texas versus Michael Glenn Sinclair Jr. Mr. Sinclair, would you please come forward? It's 30 days.
Yes, just right, it's great, with any credit, Judge. Any credit that he has.
Any credit that he has?
Yeah.
Okay. Finish this class A, Mr. This is cause number M333474. Case is style of State of Texas versus Michael Glenn Sinclair Jr. Mr. Sinclair, is that your full name? Mr. Sinclair, would you please raise your right hand? You swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. How are you doing, Mr. Sinclair? I'm doing fine. Thanks for asking, Mr. Sinclair. You're represented in your case by your attorney, Attorney Scott Rennick. Attorney Rennick, how are you doing?
Good, Judge, how are you, sir?
I'm doing fine. Thanks for asking. And Mr. Rennick, well, state is represented in this case by Attorney Andrew Hubel. Attorney Hubel, how are you doing?
Doing well, Judge, thank you.
That's good. Now, Mr. Rennick, or Mr. Sinclair, I have before me a document that is titled Motion to Revoke Probation. In this motion, it alleges that you, Michael Glenn Sinclair Jr., defendant in the above styled and numbered cause, was tried in County Court at Law number 2 of Jefferson County, Texas on February 20th, 2024. Looking at the petition, look like it's June 21st, 2023.
And I've spoken with defense counsel about that, and correct
You
me
don't
if I'm wrong,
have-
but we're in agreement.
Okay, you have no objections to a trial amendment?
No, Your Honor.
Here you go. What are you looking? Yeah.
Thank you.
Okay. Oh, you're gonna have to put first amended in the title. Okay. Now I have before me the state's first amended motion for, well, to revoke unadjudicated probation, and this motion states as follows: that Michael Glenn Sinclair Jr., defendant in the above styled and numbered cause, was tried in County Court at Law number 2 of Jefferson County, Texas, June 31st. Make sure. Is that, it must be, you got 31st, it should be 21st. Okay, any objections?
No, Your Honor.
Okay, states that Michael Glenn Sinclair Jr., defendant in the above style and number cause, was tried in County Court at Law number 2 of Jefferson County, Texas, on June 21st, 2023, for the offense of assault causing bodily injury, family member, and that on such date, the judge of said court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the above stated offense by deferred adjudication of guilt in accordance. Okay, I'm gonna change that to but deferred adjudicated. Let's see. This will be but. Well, you have by, you change that to but.
Jury theory? Okay, well, I'm part of the jury. Oh, you want that? All right.
Okay, take him back out. We in the middle of a hearing. Okay, let me read this. That Michael Glenn Sinclair Jr., defendant in the above style and number cause, was tried in the county court at law number 2 of Jefferson County, Texas, on June 21st, 2023, for the offense of assault causing bodily injury, family member, and that on such date, the judge of said court found that the evidence was sufficient beyond a reasonable doubt to support a finding of guilt for the above stated offense, but deferred adjudication of guilt in accordance with the provisions of Article 42.12 of the Code of Criminal Procedure of the state of Texas, and the judge of said court placed defendant on an unadjudicated probation for a period of 12 months upon the condition that, 1, condition C, have no contact with the victim or the victim's family, either in person, by telephone, via mail, electronic mailing, social media, or through a third person. Now, this motion alleges that the said Michael Glenn Sinclair Jr. failed to avoid contact with the victim or the victim's family, either in person or by telephone, via mail, electronic mailing, social media, or through a third party. Is that true or not true? Do you plead true or not true? True. Now, are you pleading true freely and voluntarily to allegation number 1? And are you pleading true because it is true? Mr. Sinclair, I also have before me a document that is titled Misdemeanor Plea Admonishments. Do you recognize this document?
Yes.
On page 2 of the same document, there's a set of initials on the line next to a box that's checked MTRP, which means motion to revoke probation, true to allegation 1. Did you place your initials on this document?
Yes.
Or is that is this your signature?
Yes.
Okay. Now, on page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature?
Yes.
And on the next document that's titled trial court certification, the defendant's right of appeal. You recognize this document? And is this your signature on the line that's titled defendant?
Yes.
At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. You understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Sinclair, before you signed and initialed these documents that I just showed you, did your attorney go over these documents with you? And did you understand everything that your attorney went over? And is everything in these documents true and correct to the best of your knowledge? Okay. Mr. Sinclair, are you a citizen of the United States?
Yeah, for stage 1.
No objection, Your Honor.
No objection. States exhibit number 1 will be admitted. And Mr. Rennick, you advised and counseled Mr. Sinclair. Is there any evidence that he is currently mentally incompetent to stand trial?
No, Your Honor.
And Mr. Sinclair, your attorney, Mr. Rennick, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation?
Yes.
Mr. Sinclair, I will accept your plea of true to allegation number 1. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to revoke your probation or revoke your unadjudicated probation. And your probation is hereby revoked. State, do we have a plea bargain agreement?
We do, Your Honor.
And what is the agreement?
For defendant's plea of true, the state is under 30 days jail with credit for any and all time that he served that he's legally entitled to.
Okay. Do we know the courthouse?
It's no courthouse.
No, okay. Now, Mr. Sinclair, the state is offering that you serve 30 days in Jefferson County Jail. You will be given credit for the time, any time that you spent in jail and any time that you are entitled to get by law. And you will not be required to pay the court costs because the court cost in this case is zero. Mr. Sinclair, do you understand the state's offer? You think that the state's offer in your case is fair and just?
Yes.
And do you accept the state's offer? Okay, Mr. Sinclair, I'll follow the people are in agreement that you have entered into with the state. Okay, Mr. Sinclair, this will conclude your case. You're going to stand next, stand at the end of that counter. And when the bailiff have a seat, just have a seat, they're gonna call you back up and then they're gonna finalize your case. Now, that jail time, he start that when? Today?
Yeah, Judge,
Okay,
like one today.
okay.
Judge, would it be easier?
He is gonna, you have to print him and then he's gonna be taken into custody.
Thank you, Judge.
Okay, you welcome.
I mean, that's what I'm asking.
You're not, they're gonna.
Gave you that interior, right?
Yeah.
See what I can do? Sure.
Ma'am. Waiting on paperwork, right?
I don't know what they waiting on.
Oh, I come.
Did they print it?
No, no,
They never
no,
printed it.
y'all waiting on the paper. Oh, y'all be patient with me. This is, it's going slow.
Jefferson County Court at Law number 2 is in session in cause number 23 CCCR 1398. Case is styled the state of Texas versus Jeremy C. O'Jiminy. We have Mr. O'Jiminy before the court. Mr. O'Jiminy has 2 cases, and he has first case is cause number 24 CCCR 1132. And in that case, he's represented by attorney Giles Cole. His second case is cause number 23 CCCR 1398. And in that case, he's represented by attorney Alwyn Samuel. Now, on June 10th of 2024, the court on a sua sponte motion ordered that a psychiatric examination be done by by Dr. Edward Grapan. And on June 27th, 2024, actually on July, let's see, receive this motion back. I have the motion in the file that's dated June 27th, 2024. That was conducted by Dr. Edward Grapan. Okay. And on July 3rd of 2024, this motion was, not this motion, but this report was filed in this case. And Mr. Samuel, you have received a copy of this report, is that correct?
Yes, sir.
And Mr. Cole, you also received a copy of the report? Well, actually, I was thinking Mr. Cole received because it was only filed in the case that Mr. Samuel had. Is that correct?
That's good. That's right, sir.
And we have yeah, okay, in July 19th, we did we appeared in court. And I think on that day, it was determined that Mr. Jiminy may have had another case. And Mr. Cole was appointed on that case. Is that correct? And the case was reset until September 4th, 2024. At that time, I think, was that the time when Mr. Samuel, you stated that, well, let me do this here. You had some concerns about the competency of Mr. Ojimini at that time, is that correct?
That's correct.
And you requested that another psychiatrist be appointed to conduct another a psychiatric examination. Is that correct?
That's correct.
Okay, so now let me do this. Article 1.24 of the Texas Code of Criminal Procedure basically states that all trials and proceedings shall be public. However, pursuant to the case of Lilly versus State, the right to a public trial is not absolute and may be outweighed by other competing interests, such as the interest in security, or that the defendant receive a fair trial, or to prevent the disclosure of non-public information. Now, the hearing that the court is going to have, more than likely, will disclose non-public information. And so if Mr. Samuel, if you desire to have this portion of the hearing closed to the public to prevent the disclosure of non-public information, we can do that,
Yes.
okay, to protect your client's interest.
That's correct.
So the court, the court finds that the party seeking the closure of the hearing has advanced an overriding interest that is likely to be prejudiced to his client in that it would disclose non-public information. The court finds that this request is no broader than necessary to protect the interests of Mr. Ojimini, and the court has considered other reasonable alternatives, and the court makes these findings, and these findings are adequate for the closure of the hearing. So at this time, the hearing will be closed to the public. Let me do this.